place because since this is our first meeting of the interim, I'm going to have everyone, including staff, introduce themselves. Do we have any legislators online virtually? All right. You want to start us off, Representative?
Representative Judy Weeks-Rona, District 30, West Valley City.
All right. Why don't you tell us something else about yourself since we're waiting for a quorum?
You really don't want to know, do you?
No.
No, okay. I am retired from US West, and I enjoy my gardening, my dog, and I enjoy causing trouble.
I knew that about you. I did not know that you were retired from US West, so thank you. Representative Wheatley?
Good afternoon. Mark Wheatley, District 35, Murray's, South Salt Lake, and a little bit of Taylorsville.
All right. You want to tell us something about the Wheatley family?
Well, I'm friends with Brian King. If that's is that acceptable. He likes me to sit next to him while I'm in committee.
Well, at least somebody will sit next to him. So, all right, Representative King.
Thank you, Mr. Co-Chair. Brian King. I am the representative for House District 23. House District 23 is the only legislative district in Salt Lake County that also is in another county. It's in Summit County. I have a little bit of Summit County. Summit Park is in the district, and so I'm happy to represent a portion of Summit County as well as Salt Lake County. And I'm a newlywed.
Oh,
got married in October.
Should have invited me to your wedding.
I did.
I know, he did. Okay, Representative Berkland.
And you came.
Representative Berkland.
Thank you, Mr. Chair. I'm Representative Berkland, Kara. I represent District 4, which is, no, it's not Daggett anymore. It's Rich, Morgan, and parts of Summit County. I like sports and sleeping and being at the Capitol.
Thank you, Representative. Jonathan Adams.
Good afternoon, committee. My name is Jonathan Adams. I am the policy analyst supporting this committee from the Legislative Research and General Counsel Office.
Jonathan is, if you don't know it, he is the quarterback of this team. So really, really appreciate him. And Representative Hawkins and I both rely on him a lot. So thank you, Jonathan. Okay, we'll just continue. Ms. Carlton.
I'm Jacqueline Carlton. I am an attorney from the Office of Legislative Research and General Counsel, and this is my 5th interim staffing this committee.
Thank you. And we have a new addition to our staff for this committee, Mr. Weeks.
You took my whole speech. I'm Eric Weeks. I'm a new addition to this committee and happy to be working with you. I'm just starting my 20th year here at the office.
Thank you. And if you don't feel sorry for Mr. Weeks yet, I will tell you that I was in law school with him, so he's known me longer than any of you. So, all right, Representative Acton.
Hi, I'm Representative Acton, Cheryl. I live in West Jordan. I represent West Jordan, or part of West Jordan. That's my only city, and Salt Lake is my only county, which is kind of unusual for a representative. So,
thank you, Representative Nelson. I'm Representative Abbott. I'm so sorry. Two last names. Oh, there you go.
You did. What was your opponent's name?
I can't remember.
It was. But anyways, her name was similar enough to mine. I was like.
Well, his name was Abbott.
Okay, it was an Abbott.
Cabot Abbott or something.
Yeah, Cabot. I was a little disappointed, but that's okay. I'm glad you're back. But if we'd had a Cabot and an Abbott up here, it would have just made it that much more confusing. So,
I think it's fair to say you're not the only one disappointed that Representative King won re-election. So.
Oh, well. Yeah,
all right.
Not enough of you Republicans up here as it is. You know.
So anyways, I represent Orem, part of Orem, and most of Vineyard.
Thank you. Representative Cobb.
Yeah, my name is Jay Cobb. I represent District 48, which includes parts of South Jordan, Harriman, and Riverton, and I live in South Jordan.
And tell us something about yourself.
I'm probably the most boring person you can ever meet. No. No, I have 2 kids in college, 2 kids at home. I will brag about my son, if that's okay. He's a sophomore and got a 36 on the ACT, so there you go.
I'm going to tell everybody you fly in a private jet more than anybody except for Representative Schultz. So, is that fair?
That may be fair.
Okay, Representative Malloy.
Thank you, Mr. Chair. My name is Corey Malloy. I'm the House Representative for House District 52 in Lehigh, and have most of Lehigh and a small chunk of American Fork and a small chunk of Saratoga Springs.
Thank you. And I know Senator Escamilla snuck in and thought that she got out of this, but Senator Escamilla.
Thank you, Mr. Chair. Senator Escamilla, Senate District 10. That's the Northwest Quadrant of Salt Lake City. About 60% of West Valley City and all Magna are in my district now, and I'm the minority leader and been in the state legislature for 15 sessions.
All right, thank you. It's a good thing that Representative Hawkins isn't here, because even though he's co-chair, we wouldn't have a chair for him. So that might be a problem moving forward in this room. We probably have other committee members that aren't here. Okay, so we now have a quorum, so I'm going to call the meeting officially to order. And can I get a motion to approve our minutes from the November 16th, 2022 meeting? All right, we have a motion from Senator Kennedy. Oh, thank you, Senator Kennedy. We have a motion from Senator Kennedy. All in favor, say aye. 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 Okay, Senator Kennedy, would you like to introduce yourself? You did sneak in.
Mike Kennedy, hello. It's good to see you. And I'm from North Utah County, and this is my 9th year of legislative service, and happy to be on the committee with Senator Weiler and others. Thank you.
Senator Kennedy is a doctor and a lawyer.
That I am.
And I think the first politician in our country's history named Kennedy, if I'm
Yeah,
not
it's
mistaken.
just probably absolutely true.
Yes. Okay, thank you. All right, we're now going to hear from Jonathan Adams, and he's going to discuss a survey that we're going to distribute right now and ask you to fill out during this meeting to research the needs as well as present on the statutorily required reports due to the committee. So, Mr. Adams.
Great. Thank you, Senator. Here, let me share my screen here. Bear with me. Well, as it relates to the survey, it should already be distributed. So if you look before you, you should have a piece of paper, just a brief 4-question survey. It's something I kind of quickly designed to help me better assess what the committee's research interests and needs are as it relates to the study item list. So if you wouldn't mind filling that out at your convenience throughout this meeting, I'll pick it up from you afterwards. And really the goal of that survey is just to help me better serve your needs as a committee and produce research for you throughout the interim. And then as it relates to the statutorily required reports, again, give me 1 second here.
We need all the legislators to snuggle up a little bit, so
Yeah,
welcome.
We recognize it's a small room here. Here we go. So you should also have in front of you this list of all the reports that are due to the Judiciary Interim Committee. So this list includes both the 16 statutorily required reports as well as 6 reports that are available upon request to the committee. I've highlighted here 2 new reports that are available to our committee. These are 2 new required reports. The first is the Justice Court Reform Task Force report, which is due on or before November 30th. And there's also a report related to juvenile justice and school discipline issues. And the thing I mostly want to highlight here, we're not going to go through each of these reports, obviously, is that as we receive these reports, I will be emailing them out to the committee, but I'll also be including them on the related links tab of our committee webpage. Additionally, you can assume that most of these reports won't be agendized unless otherwise noted by the chairs. But if as you review this list, you see studies or reports that you would like to receive presentations on, please let me or the chairs know, and we might be able to arrange that. So thank you, Senator Weiler. That's all I had on that item.
Can we pull up another chair for, we're going to squeeze you in right here, Representative. Yeah, we just need to pull it over. Oh, we got one here. All right, well, I commented before the the last three of you joined us, that it was a good thing Representative Hawkins wasn't here because we wouldn't have a place for him. He's traveling today. And I know Representative Lisenby is going to be especially excited about this, but we've all introduced ourselves except for the three of you. So we're going to go back and start with Representative Lisenby.
I'm so excited.
I knew you would be.
Thank you, Senator. And I serve in House District 14, which is Syracuse, Clearfield, and Layton, parts of all three.
Thank you. And then we'll go to Representative Welton.
I'm Doug Welton. I represent South Utah County, Payson, Santaquin, Elk Ridge, Salem.
And he is a school teacher or works in public education. Okay, and Representative Stephanie Gracious, am I saying that right?
Yeah.
I always worry that it's
No, you're
supposed to be
good.
gracious.
Nope.
I'm supposed to be gracious.
I have
or-
a hand towel that says goodness gracious.
Okay,
on it, though.
there you go.
So Stephanie Gracious, House District 50. It's most of western Utah County, Eagle Mountain, Cedar Fort, Fairfield. And then I go down south to the lake to Genola and West Mountain as well.
All right, and we all said stuff about ourselves, and so I'm going to tell everybody that you're also a foster mother, right? And Representative Welton, we would love to have you stay, but you're not a member of this committee. This is Judiciary.
Is that your final ruling?
Yeah, that's my final answer. You can phone a friend if you'd like. So, where were you headed?
Transportation.
Okay, well, they're probably.
Can I be a guest?
You're welcome to stay. We're just not going to let you vote on anything. So, okay, well, that was fun. Back to a serious note, and when I first joined the legislature in 2012, I think I've been here longer than everyone except for a couple of the Democrats here to my right. We spent a lot of the interim committees hearing reports from these various agencies. And as Jonathan said, we can do that. And if you ever want to hear a verbal report, please let me or Representative Hawkins know. We have, as the legislature has become busier over the past decade, we've moved more and more of the reports to written reports, but that doesn't mean we can't hear from them. But what we were finding was a lot of times if we wanted a 5-minute report, we got like a 39-minute report, and it was just kind of monopolizing the meetings. And so I do hope when Jonathan emails those out to you during the interim that you will take a peek at them, and if you have questions, we do want to follow up on those. So thank you. So Jonathan, did you go through the current or amended list of study items? Okay. Do you want to present that to us? Okay, yes.
Thank you, Senator Weiler, and for good or ill, committee rather, you'll be hearing from me a lot today. So let me just pull this up. Bear with me. Okay. So for this next agenda item, and let me make this a little bit bigger. You should also have a printout of this if it's easier to refer to. I'm having some issues making it a little bigger on my screen. But we're going to just quickly review the process for reviewing, modifying potentially, as well as adopting the study item list. So here I've got a list of, we have 8 study items that the chairs reviewed and approved, as well as the Legislative Management Committee. So rules permit this committee, or require the committee to review and adopt either this proposed list of study items or a modified one. So I've got that available for the committee. You've got the handout. Feel free to review it. I'm happy to answer any questions related to any one of these study items. But at this time, the committee is able to review it, add to it, subtract from it, or make a motion to approve it as is.
All right, and so at this time, I will accept a motion to either adopt the current list of study items, which Representative Hawkins and I have approved, or a motion to amend the list, and I won't be offended if anybody wants to amend it. But since I don't have a co-chair here, I will need someone to step up and make a Is that you, Representative Lisenby?
It is.
Okay.
Thank you. I have a clarifying question.
Sure.
Would that be appropriate?
Yes, it would absolutely be in order.
Thank you. So on the restitution reforms, in the context of the last couple of years as we've worked through this, what's the nature of the restitution reforms that we'll be studying during the interim?
I'm going to kick it to Mr. Adams to answer that.
So we're actually about to hear quite a bit more about that in today's meeting. So we've got some presenters lined up from the Office of State Debt Collection, as well as Representative Perucci has some stakeholders here as well to identify some of the concerns they have.
Oh, I see. So I am actually aware of the concerns that Representative Perucci will be presenting. Is that the total reform that we're looking at, or are there other items on
So
restitution?
the other item, that is the primary one.
Okay.
The other one is a status update from the Office of State Debt Collection as it relates to implementing HB 216 from last year.
Okay, excellent, thank you. With that, I'll make the motion that we approve the current list of interim committee study items.
Thank you. That motion's in order. Any discussion to that motion? Seeing none, all in favor say aye. Aye. Any opposed? Chair rules that motion passes unanimously. We're now going to have Jonathan review the authority to open judiciary-related bill files.
Yeah, so this is also on that same handout. I have it here on the screen. So during the first interim committee, the committee has the ability to give the chairs the authority to independently open up committee bill files that are related to the approved study item list that we just approved. So what will happen is, and this is something that we did last year as a committee, the chairs can jointly agree to open up a committee bill file, again, if authorization is given. And then at the next interim meeting, the chairs can let the committee know, committee, we've opened up this committee bill file on your behalf as it relates to this study item. So the possible motion before the committee would be to authorize the chairs to do that.
All right, thank you. And I just want to add that there's been a trend over the past decade to open more and more committee bill files, which is fine. That's one of the reasons why we passed the most bills ever last session. And I just want everyone here to recognize that if you vote to open a committee bill file, that's fine, but you're also voting to put that ahead of all of your non-priority bill files. And I'm not sure that everybody, always, does that math in their head, because the committee bill files are treated like priority bills and are drafted first, or, close to being first. Okay, so we need a motion to grant authority to the chairs to open bill files on behalf of the committee, if someone's so inclined to make that motion. And normally, we would do that only after, or with discussion to the committee. Does anybody want to make that motion? Representative, well, I'll go to Senator Kennedy.
Thank you, Mr. Chair. Motion to authorize the chairs to open committee bill files for approved study items.
All right, thank you. Any discussion to that motion? Seeing none, all in favor say aye. Oh, yes, I'm sorry. Representative Lisenby and Representative Berkland in that order.
Okay, thank you. So, did you want to go ahead? Okay. So in our caucus today in the House, we had a discussion about the number of bill files that are open currently, and it's a pretty big number. Wow. And one of the other committee members in another committee made a motion earlier today in a different committee that we limit the number of, or that they limited the number of bills that a chair could open unless they came back to the committee. And I do think that might be helpful, but I don't want to get crosswise with if there's certain intent by the chair. So I don't know what that number looks like, but I think that might be an appropriate substitute motion.
Do you want to offer a number as a substitute? I welcome that, because I'll tell you as a chair, I've never intentionally abused that process, but I can't say that for everyone in the legislature. So.
Understood. Well, so I don't know. Maybe should we start with? I was thinking 5. Should we start with 5?
Yeah, that's what I was thinking. All right, so we have a substitute motion to authorize the committee chairs to open up to 5 bill files without coming back to the committee. Is there discussion to that substitute motion? So let me ask Senator Kennedy, would you welcome that as a friendly amendment?
Most certainly.
Okay, all right. Any further discussion? Seeing none, all in favor say aye. Aye. Any opposed? Chair rules that passes unanimously. Okay, we are just moving through our agenda like you wouldn't believe. So, Jonathan, we'll go to you again. Oh, I'm sorry, Jacqueline. My bad. The gavel?
Yes.
She wants the gavel. No, I'm just kidding.
Okay, well, thank you, Mr. Chair. Once again, I'm Jacqueline Carlton. I'm an attorney with the Office of Legislative Research and General Counsel. And this is a presentation that our office gives every interim to this committee. So I know some committee members are familiar kind of with what the purpose of this presentation is. But essentially, this is a report from our office on cases where the Utah Court of Appeals and the Utah Supreme Court has tried to call to the attention of the legislature statutes that might be in need of clarification or modification, or maybe policy issues that the legislature should consider. We don't include trial court decisions in this report because those aren't easily accessible to us or searchable. So it's just limited to Utah appellate courts. So we have 3 cases from this past year. I'm just going to briefly go over each case, and I have a recommendation for the committee on each case. I'm also happy to answer any questions that the committee has as I go through the cases. So the first case is In re AG from the Utah Court of Appeals. This was a child welfare case where the court had set a date for trial regarding the termination of parental rights of a mother. But the day that the trial was set to begin, the mother stated to the juvenile court that she was going to voluntarily relinquish her parental rights. However, after the hearing, she wouldn't sign the document for voluntary relinquishment, but the juvenile court determined that she didn't need to and just went forward with terminating her parental rights. So the issue that was before the Utah Court of Appeals was whether the Utah Code requires a parent to sign a document before they can voluntarily relinquish their parental rights. So if you look at the statute here, I think one of the issues raised in the case was this language in subsection 1, where it essentially says that the parent shall sign or confirm the relinquishment before the court. But later on in the statute, it kind of implies that the parent is going to sign some kind of document. This was kind of the conclusion that the court reached, which is that the statute requires a parent to essentially sign a document at some point stating that they're going to voluntarily relinquish their rights. So at the end of the case, the court says, if we've misperceived legislative intent of the statute, the legislature is free to amend it. We've frequently seen this type of language from the Utah Court of Appeals over the years, where the court essentially kind of tells the legislature, you're free to correct us if you think we got the policy wrong. But I think that after reviewing the statute, even though the court isn't specifically asking the legislature to do anything, it probably would be beneficial for the statute to be clarified on whether written relinquishment is required before a parent can voluntarily relinquish. And so my recommendation to the committee is to open a bill file to clarify the statute.
Thank you. And let me just pause there for a moment. So my experience as a practicing attorney, and I was in court this morning, is that if someone, party, makes a representation in open court, with the judge there, really whether they're under oath or not, usually that's treated almost the same as a signature. You may like that or you may not like that, but I just want to comment, if we do nothing as a legislature, this appellate court decision that's already on the books will say, the law in Utah will be you don't have to sign if you've made that representation in open court. And so I'm frankly okay with that, but I'm not opposed to us opening a bill file and either doing the same thing legislatively or clarifying that as a legislature we want the parent to have to sign. So any discussion on that? And also, any one of you or any legislator could take up this issue without the committee opening a bill file. I mean, that's, with all due respect to Ms. Carlton, we can do that as a committee, or if one of you say, hey, this is right up my alley, I want to do this, we could not open a committee bill file and let a single legislator do it. So any thoughts or discussion on this? Representative Lisenby?
Thank you. I just had a question, and maybe you can answer this, Mr. Chair. Is the hearing process really clear on this can't be revoked? Is there some information that's given in the form that isn't given during the hearing process?
I think that's a great question, and I think that would be up to the judge. Now, if you make a plea in open court, you have to be advised of your right because it's a criminal plea, and so you're giving up some of your liberty and rights. So it would depend on how the judge handled that. But what I read, and Jacqueline, if you see it differently, I think that this mother was on the precipice of going to trial to lose her rights, and rather than enduring that and being cross-examined, and maybe that would have been a humiliating experience, she showed up in court and said, I surrender, and then they canceled the trial, and then afterwards she refused to sign. And so that's kind of what I'm reading into this, which is kind of an interesting way to handle things. But generally, I think every time I've been in courtroom, if somebody's given up rights as important as parental rights, usually I see the judge, especially if they're not represented by an attorney, bend over backwards to make sure that they understand exactly what they're doing. But there's not necessarily a written script for that, if that answers your question. We'll go next to Representative Nelson Abbott. I called him Representative Nelson before you guys got here.
My question was along the same lines as Representative Lisenby's. It sounds like there's not a statutory requirement that the judge cover certain things prior to that being stated on the record. Is that right?
I think that is correct, at least in my experience, but I will tell you, every district court judge's biggest fear is being overruled on appeal. And so normally, they take great caution to make sure that they've dotted every I and crossed every T. But as a legislature, we have not given them a script or specific instructions on how to do that.
And then my other question was, you were going through those slides fast. When I was reading those slides, I thought it was the opposite of what Senator Weiler said, in that they said it had to be in writing, but Senator Weiler
Yes,
said.
it has to be, they have to sign a document
So the
at
court,
some point.
So the court
says
overruled.
Yeah,
Okay.
overruled the juvenile.
Yeah, I missed that, so you're right. So if we do nothing, then the rule of law will be that they do have to sign.
Okay.
So I missed that, I'm sorry. Going back, is this Representative Birkland? Yes. I'm sorry, they're sharing a microphone, so I'm.
Thank you, Mr. Chair. A couple of questions. Number one, I just want to clarify, this is not in cases of abandonment, correct?
Like a parent abandoning their child?
Yes, I just know of a few cases where it's
I'm not
abandonment
sure
and
what
they'll
the
step in.
requirements for
Okay.
that would be. This was just a specific case where the parent was set for trial to determine basically whether they were going to lose their parental rights.
Okay.
And they decided beforehand they were going to just relinquish them.
So most of these deal with cases of abuse or neglect, so the abandonment would fall under neglect.
Under
So,
neglect,
yeah.
okay. And just to clarify, I think you answered it, but if we do nothing, then the court took its action.
They said you have to sign.
And-
I
okay.
misread that, I'm sorry.
Okay, you have to sign. And so in this case, that child currently is still a ward of the state?
I don't know exactly what the circumstances in this case of the kids are now, but I would assume because they overruled the juvenile court, it would go back and probably go to trial because she's not going to voluntarily relinquish.
Okay.
So under the current, as I read, now that I understand it, as I read the current law, if someone showed up for a termination trial and they said, I surrender, then the judge will say, well, then you need to sign, maybe explain their rights and say you need to sign here or else we're going to proceed with the trial. So that's the current law, which I'm also okay with that. I don't have an issue with it, but I also am fine if we want to clarify. Are we going back to you, Representative Abbott? Okay, somebody, Representative Acton.
I'm thinking of this parent. I think it would be easier for me as a parent to say my children were taken from me than to say I relinquished my children. But are you saying that they have to go to, currently they would have a trial to have the children taken?
Normally, yeah.
They can't verbally state that they want, I mean, that they're willing?
So that's a great question, and I'll let Jacqueline weigh in as well, but I have some experience in this. So there's this word on the street, like, let's say a girl gets pregnant and she's not married, and then the father doesn't want to pay child support, doesn't want to be a father. So there's this understanding out there on the street that he can just sign away his rights. We don't let deadbeat dads off like that. And so that absolutely is not the law in Utah. People on the street believe it's the law, and I have clients call me and it says, oh, you know, my former boyfriend says he'll sign away his rights. I'm like, that's nice, but we're still gonna get child support from him. And so if we let men do that, and I'm sorry, it's usually the men, we would have thousands of men do that, and then they would, you know, then they would be on welfare and taxpayer supported. So we don't let them off that easy. Now, it's a little different if DCFS, it's usually DCFS, is coming after the parent for abuse or neglect, and they're facing a trial. At that point, we will let them sign away their rights, but it's because the state has basically, in a civil prosecution, basically said, we think that you're a danger to this child. The child's better off without you. And so in that instance, they can do it. Does that answer your question?
Yeah, okay, that's.
Jacqueline, do you have anything to add to that?
Okay, thank you.
Okay. Other questions? All right, does someone want to make a motion? Do you want to, let's do these one at a time. Does someone want to make a motion to open a committee bill file to address this situation? And we don't have to, and I'm fine if we do, or I'm fine if we don't, but does someone want to make that motion? Representative, I'm sorry, that's the second time. Senator Escamilla.
So move, Mr. Chair.
Okay, we have a motion to open a committee bill file to do what?
To address the requirement of signature for parental relinquishment.
But how do you want to address it?
Do I have to have an answer?
No, you don't have to.
I just do have one concern.
Okay.
And that is, in some of the court cases, I want to make sure that there is, usually there is, but I don't know, I would like to check with the courts if there is an interpreter, because if there's a limited English proficient individual parent, that they're understanding that whatever they're saying there will mean that, which I think they do, but I would like to check.
And let me address that.
Okay,
There's
thanks.
always a vehicle for an interpreter to be requested. That has to be done a few weeks before the hearing. Some people do it, in my experience, even though they don't need it. Other people don't do it, even though they do need it. And so I think, and Michael can nod either way, I think the court would have the discretion if someone showed up without an interpreter to delay the hearing or postpone the
okay,
hearing,
perfect.
which is what I think they would do.
Okay.
In most instances. Okay, we have a motion to open a committee bill file. Does anyone want to speak to that motion? We have a light over here in the, Representative Birkeland.
Yes, I'd actually like to make a substitute motion if
Okay.
it's appropriate. I would just like to open that bill file. I think there's a lot of heavy issues this committee needs to address, and this is something that I think is a pretty simple issue. Parents should be fully informed and sign away those rights, and I'm happy to take that on if that's appropriate.
Individually?
Yes.
Okay. If you're looking for a Senate sponsor, I'd be interested. Okay, we have a substitute motion that we don't open a bill file with the understanding that Representative Birkeland will pursue this on her own. A discussion to the substitute motion. And she's going to make sure that we codify in statute the current ruling that they do have to sign away their rights. Okay, no discussion. So all in favor of the substitute motion, say aye.
Aye.
Aye. Any opposed? Chair rules that passes unanimously. All right, Ms. Carlton, let's go to the next one.
Okay, the second case.
Oh, sorry.
The second case is Taylor v. Taylor from the Utah Supreme Court. This is a case where a husband and wife had agreed to arbitrate their divorce. But after arbitration, the husband challenged the arbitration award in court and sought to get it invalidated. And so some of committee members may know this, but arbitration is an alternative. Parties try to resolve an issue outside of court. And so the parties essentially agree to have a neutral third party make a final and binding decision that resolves the dispute between the parties. And so one of the issues in this case that the court looked at was whether parties can arbitrate a divorce or other family law action under the Utah Code. And so currently in code, the Utah Uniform Arbitration Act governs the arbitration process in Utah. It's a pretty broad act. It applies to any agreement to arbitrate after May 6, 2002, and the parties can arbitrate any existing or subsequent controversy. The issue in this case is that the Utah Code is essentially silent on arbitration in family law. So what the court's decision does is it tries to reconcile basically kind of the Arbitration Act with family law policy. And so what the conclusion that the court comes to is that yes, parties can arbitrate a divorce, but there's some exceptions to judicial review. For alimony and property disputes, a party's ability to challenge that award in court is going to be limited to what the ground specified in that arbitration act. But on the issue of child support and custody, the court said that Utah law doesn't permit a party to bargain away the rights of their child. And so a district court is still going to retain the authority to hear challenges to an arbitration award on the issue of whether it was in the best interest of the child. And so, as I kind of mentioned several times throughout the case, the court kind of implies that they need additional guidance from the legislature on this issue. And I think even though this issue was specifically about divorce, it raises questions about arbitration in other areas of family law, things like guardianships, adoption, child welfare. And so at the end of the case, the court says, that the legislature is best equipped to break the silence between the statutes. And so my recommendation to the Judiciary Interim Committee would be to open a file to kind of clarify the use of arbitration in family law. One suggestion that the court makes is that some states have adopted the Uniform Family Law Arbitration Act, which would address some of these issues. And then another option is, as staff, we could look at other policy options for the committee to consider.
Okay, I just want to add a little bit to that. So 98.5% of all of divorces in this state settle, and many of them settle through mediation, not arbitration, mediation. In mediation, usually the parties are in different rooms in the law office, and then you have a trained mediator who's often a lawyer, go back and forth with offers, and they eventually come to an agreement, and then it's written up and they sign it. That's how most people get divorced today in Utah and every other state. Very few people have a divorce trial. That would be in the other, 1.5%. Arbitration is a similar process, except you'd be in the same room, and you would basically be hiring someone, usually an attorney, as a private judge, and that you're going to both, answer their questions and put on your evidence, and then that arbitrator is going to make a decision that's typically binding, and then you're stuck with it. And the thing about arbitration is you cannot generally appeal it. So if you go to a trial with one of our state court judges and you don't like what the judge decided, you can file an appeal with the Utah Court of Appeals. You'll usually lose, but you have that opportunity, and some people win. If you go to an arbitrator and the arbitrator rules against you, theoretically you are done. You can't appeal it. So, and I'm not sure that every divorcing party, especially if they didn't have an attorney, would know that up front. Now, the last thing I'm going to tell you is every person on this committee, every legislator has probably signed a contract with an arbitration clause, whether you knew it or not, and you probably did that when you rented a car or went to the doctor's office or something like that, because they give you the form and you just sign it. In my experience, arbitration is almost always a bad idea because it can be quicker than court, but it can be longer than court. But instead of having a judge that the taxpayers are paying for, you have a judge that you're paying for. So you're often paying your own attorney, and then you're paying for half the arbitrator. A lot of agreements have 3 arbitrators, so you're paying 3 lawyers to be your judges, and then it gets usually much more expensive than going to district court. So that's my 2 cents. So right now, if we do nothing, what's the status of the law?
I mean, if you do nothing, the status of the law is just going to be this case for divorces. I think there's still a question.
It did allow it, or it didn't allow it?
It allowed for arbitration in divorce cases, but for judicial review, it's still going to be limited, like you explained, with the exception for child support and custody issues.
Okay, and so for husband and wife to agree to arbitration for divorce, which I have personally never seen in my life, they would basically be signing a contract, and so it would be like enforcing a contract between the two. So, okay, any discussion? Anyone want to make a motion, or does anyone have any questions about what Ms. Carlton presented? Representative Abbott.
Well, I could imagine a situation where a couple might say, okay, we've got to value this business and we don't want to go to trial over that, so let's submit it to an arbitrator and they'll determine the value of the business or something, right? So I can imagine scenarios. I think the court kind of addressed my biggest concern, and that was the kids, because they don't really get a say in arbitration.
And they're not represented in the arbitration.
They're not represented. So I kind of think the status quo is, unless somebody says different, I kind of think what the court decided is probably reasonable.
So I think the only reason, in my mind, that we'd want to open a committee bill file would be to say you can never arbitrate a divorce. Yeah. Which, I don't know that that's our decision either, but Jay, or Representative Cobb?
Just a quick question. For all divorces, is mediation mandatory?
I think yes. When I started practicing in 1996, I would have said no. But let me just say this. If it's not mandatory, it's quasi-mandatory, because there's not a, Mr. Drexel can overrule me, there's not a judge that I know of in this state that will give you a trial date in divorce without you going to mediation. And usually, they make you then, if you go to mediation and fail, then they'll usually try to set up a judicial settlement conference where you do a second mediation with a sitting judge, but not the judge assigned to your divorce. So
every party's going to go through some ADR process somehow.
unless they just get together, which some couples do because they can't afford attorneys, and agree on everything. So, is there another question from Representative Acton or Representative Abbott? I've got another light flashing. So, okay. Anyone else? Does anyone want to make a motion? And I'm fine if we don't. I'm fine if you do. All right, we're going to move on.
Okay, and finally, the third case is State v. Mitchell from the Utah Court of Appeals. This is a case about the child rape statute. So in the underlying facts of the case, the defendant was convicted of both rape of a child and aggravated sexual abuse. He appealed his convictions to the Utah Court of Appeals, and one of the issues he raised was regarding the jury instructions. Essentially, his argument, and I'll explain more about what it means in just a second, but was that the jury instructions were kind of confusing, potentially, because they suggest that someone can be convicted of rape of a child by simply touching a child without any penetration. And so when you look at the statute, you'll see here that it's defined as sexual intercourse with an individual who is younger than 14 years old. And then the following provision says, any touching, however slight, is sufficient to constitute a violation of the statute. In this case, the jury instructions stated that for purposes of the child rape statute, sexual intercourse can be accomplished by any touching, however slight. But when you look at this statute and in comparison to the sexual abuse of a child statute, you'll see that it also defines sexual abuse as any touching is sufficient enough to constitute a violation. So both statutes seem to require touching. So I think the issue here is over how touching, though, constitutes sexual intercourse, because I think the jury instructions were technically accurate. And so the defending, his argument was, well, that's potentially confusing. So I think really what the issue is what does sexual intercourse mean under this statute? The court didn't really reach a conclusion in this case because the defendant admitted to penetration, which they said satisfies the ordinary definition. But in a footnote, the court says that the legislature might consider providing a statutory definition of the term sexual intercourse that explains whether penetration of a child's sexual organ is required and which body parts must be involved so as to distinguish this crime from other sexual offenses against children. And so my recommendation to the committee would be that it either refer this issue to the Law Enforcement and Criminal Justice Interim Committee, which this committee has referred these type of statutory issues when they deal with the criminal code to that committee, or the committee can open a bill file itself to clarify the statute.
All right, Representative Berkland.
Thank you, Mr. Chair. Is it current practice for the penalties to be harsher for rape over abuse?
Yes, I think that's correct.
And harsher in the sense of the actual prison sentence and fine, but also in how you're listed on the sex offender database. So both.
Okay, so it seems to me that we do really need to make sure we clarify one versus the other. So
I agree.
So that someone who penetrated isn't being let off on a lighter sentence, frankly. And vice versa.
And vice versa, yeah. I agree. I think this is one that we can't ignore because I think that the two statutes are, they create an ambiguity that is unacceptable, to me at least. So any other questions? Senator Escamilla.
Sure. Yes, and I would rather have it stay here than send it to the law enforcement. I think it would be nice to do some research on the definition of, just, defining the wording. We don't have it in code, any definition, correct?
Yeah, and let me just, so the House members know, in the Senate, during the session, we don't have a standing law enforcement committee. So if we refer it to the interim law enforcement committee, it'll come right back to me and Senator Kennedy and Senator Escamilla during the session anyway. So the House splits those two committees, the Senate combines them. So that, I'm speaking in favor of, I don't think we need to refer it. All right, does somebody want to make a motion?
So move.
Your motion is to open a bill file.
Correct.
Do you have a preference as to which direction you'd like the law to move in? Or
Well,
what-
I mean,
what-
a bill file that defines, because it doesn't seem like we have defined
Okay.
intercourse, correct?
And
For
do you
the
agree with
child
what Representative Berkland said, that we'd
Yes.
want the
Yeah.
penetration to be?
in a different level
Yeah.
of, yes.
All right, and before we go any further, let me just say, these situations often arise, sometimes maybe a father or a stepfather is bathing a young child, and sometimes there's a custody dispute, and then there's allegations made, and the child's too young to talk, and maybe it happened, maybe it didn't. So I just want you to understand the context where these often are. Most of the time I've seen this, I'm not a criminal attorney, but most of the time I've seen this has been in bathtubs type situations. I mean, obviously there are other situations where it could arise as well. Okay, we have any discussion to that motion? All right, all in favor of the motion to open the committee bill file, say aye.
Aye.
Aye, any opposed? I just want to add, after my first session, I asked John Fellows, I said, who in your office is like reading all of the appellate decisions and telling us like what the courts are calling out for us to do as legislators? And he looked at me and said, would you like us to have someone do that? And I said, yeah, I think I would. So I'm kind of, it's my fault you had to do that, Jacqueline. But after that, I had some law school students at BYU go through like the last 10 years and look for everything that got called out by the appellate courts. And then I sent that list to all of the attorney legislators in the legislature at the time. And I don't think we ever did anything with it. Brian, do you remember? But anyways, I tried. But I thought this was a very helpful exercise, so thank you. Oh, Senator Colmore, would you like to be recorded as an aye or nay on opening that committee bill file?
Yes, aye, thank you.
All right, thank you. Welcome. And Senator Colmore, we all introduced ourselves. Would you just take a moment to introduce yourself to the public as a beginning of this interim?
Will do. I'm Kurt Collimore, Senate District 19, which is the southeast part of Salt Lake County and a little bit of northeast Utah County.
All right. Thank you. And something that you may not know about Senator Collimore is he was a piano and violin major in college. So is that accurate? Mostly accurate?
I was a music major with my instruments being violin and piano, yes.
Okay.
Yep.
And he's a really, really good violinist. I haven't heard him play the piano, but I've heard him play the violin with Representative Ballard playing the piano, though, so that was fun. Okay, thank you. We'll count you as an aye vote. All right, our next agenda item is restitution reforms. We'll start off with Jonathan Adams.
Thank you, Senator Weiler. I'm going to present briefly. Give me 1 second while that comes up on Zoom. Okay, so something new that staff is wanting to do more regularly this interim is give brief overviews and some background context to the study items before the committee. So let me say before we dive into this that I'm not an expert on restitution. We're lucky to be joined by a lot of officials and experts who maybe can address the committee's questions as it relates to that. But I did just want to briefly equip the committee with some high-level context. So first, in terms of how the statute defines restitution, restitution is the payment of pecuniary damages or financial monetary damages to a victim. And a victim is any person who has suffered pecuniary damages that are proximately caused by the criminal conduct of the defendant. Something that some may not know is that this definition of victim would also include the Utah Office for Victims of Crime, in as much as that office provides payments to or on behalf of victims. At the risk of oversimplifying it, I understand the restitution process is playing out in 3 phases. The first is determining the amount of restitution owed, then the court makes the actual restitution order, and then we kind of move on to the enforcement and collection of restitution. So as to the determination of restitution, the court looks at all relevant facts to establish an amount that fully compensates the victim. So here at this stage, the court isn't as concerned or isn't focusing on the defendant's resources or their means. They're looking at what it would take to make the victim whole. And some of those relevant facts that the courts can consider are invoices or bills of damages to the victim impact statements, and some other information provided by the law enforcement pre-sentence investigation, as well as info from prosecutors. So then that kind of takes us to the court order stage of things. Now, the court will typically enter a restitution order at sentencing, but there may be times where the court instead schedules a restitution hearing to better assess and understand what the pecuniary damages are and what restitution is owed. And as it relates to collection, the court is the one responsible for setting the payment schedule. And at this stage, the court can consider the defendant's means and the rehabilitative effect of that payment schedule. And then it's the Office of State Debt Collection, as the name would suggest, that collects the actual payments. 2 other things I wanted to flag on this collection portion. During the so-called criminal period, which is the period where the defendant is incarcerated or under supervision, there isn't any interest that accrues on the restitution amount. But upon termination of the sentence after the criminal period, restitution debts are subject to interest, and they're also subject to other civil remedies that other debts are subject to, such as garnishment. Before we move it on to our presenters, I did just want to highlight some of the recent reforms in this space, because there's been a lot of hard work in this area, and it's pretty complicated. So in 2021, the legislature passed HB 260. It did several things, but the key takeaway for this committee to understand is that it simplified the restitution process. It also prohibited interest from accruing on criminal accounts receivable. That's something I mentioned briefly on the previous slide. And it also allowed for the forgiveness of certain debts, such as when a victim agrees or consents to the remittance of unpaid restitution. And then the legislature followed up the following year, last year, with HB 216. So whereas HB 260 was really focused on simplifying the restitution process, HB 216 was focused on improving the transparency of restitution amounts. Specifically, HB 216 required the Office of State Debt Collection to create a website that would provide defendants with detailed information about the debts that they owe. The Office of State Debt Collection was to implement this website and make it live by the end of last year. It's my understanding, working with officials, that has not yet been fully implemented. So something that we'll hear today from presentations is a status update on the implementation of that website. So with that, that concludes my presentation. Happy to answer any questions the committee may have, or we can proceed to hear from our presenters on this.
All right, any questions for Mr. Adams? Seeing none. Is Paul Bowers here? Okay, well, Mr. Strong, why don't you introduce yourself and let us know who you're representing today.
Thank you, Dan Strong. I'm director of the Sentencing Commission. And sorry, thank you, Paul. I have to run downstairs for a different presentation that's happening right now. So in any case, I just wanted to add today that for your information, the Sentencing Commission...
Oh, I'm sorry. I just meant to announce, I apologize for interrupting you. Pursuant to the new legislative rule, anyone appearing on video virtually will need to tell us their place of residence. We'd like to know if they live in or outside the state, and they need to enable their video so we can see them. So I meant to announce that at the beginning of the meeting, so that we will be enforcing that new policy during our interim meetings. So Mr. Strong, I apologize.
No problem at all. Thank you so much. The Sentencing Commission has had a working group since actually before my time here, focused specifically on restitution. And so just seeing that the committee was looking at this today, we asked if we could kind of have a minute to talk about that group and its process and maybe offer it as a potential avenue for any changes or reforms the group's looking at. So that working group has pretty substantial representation from the AG's office, Utah Office of Victims of Crime, Office of State Debt Collection, we have prosecution and defense, we have House members, including Representative Lisenby, who've been on that working group in the past, the courts, Mike Drexel, who's here, some victim advocate representatives, corrections, and AP&P, and Board of Pardons and Parole. I'll say my experience with that group, it's really good and interesting, varied perspectives and real experts in the room. Also say, in my experience, it's been very difficult to tweak or move anything in the restitution space without upsetting a different important interest. So it's one of those areas where, you know, there's really important considerations here, both in making sure that someone who's convicted of a crime can eventually move on with their lives and not be destroyed forever by the fiscal responsibility. On the other hand, you know, that person's responsible for damage to a victim who could go uncompensated. And those things are really difficult to balance. I think this group has done a good job of making consensus improvements in recent years, and some of those Jonathan just summarized. We also had House Bill 50 last year, one of Representative Lisenby's bills, which made changes in how these hearings happen with pleas in abeyance, clarified deadlines and how restitution is collected up front, clarified the impact of civil settlements, and made some changes to how OSDC structures their payments. And then all those changes were unanimously supported through the legislative process. So I'm not here to suggest that the restitution should not be pushed more in one direction or more in another. But I think if this committee is interested in kind of more consensus-backed, narrow changes that can get buy-in from the stakeholders, we wanted to offer ourselves up as a venue for that. So I think that's basically all I have today. Thank you.
Thank you. Any questions? Oh, we'll go to Representative Lisenby.
Thank you, Mr. Chair. And thank you, Dan. I thought about as I first heard about these proposed changes. I do think this is somewhat of a different situation. I think this is a super narrow just fix. And so I don't know that it would need to go through the working group process because I think it's just very, very specific. But that's just a thought that I had. I'd be happy to talk with you offline about it.
Of course, thank you. And yeah, as far as the substance of what change is being sought today, I'm not sure I'm well versed in that, so that makes a lot of sense. Thank you.
All right, thank you. Any other questions for Mr. Strong? All right, thank you so much. So we're not going to hear from Mr. Bowers? Or, oh, you just let him go first, because, okay, come on up. Please introduce yourself and tell us who you're representing.
Yes, thank you. My name is Paul Bowers. I'm the manager of the Office of State Debt Collection.
Thank you for being here.
Welcome. Thank you for having me. So yeah, my office's role as far as restitution goes, obviously, is to collect. We are very aware that our collection actions can be very stressful and frustrating for the people that we collect against. However, it's our position that the victim needs to be made whole at the same time. So common methods of collection include voluntary payments. We do tax refund levies and wage garnishments, as I believe Jonathan mentioned earlier. I just wanted to give a couple updates on HB 216. Really, the two major requirements were for my office to create a new settlement policy, which has been finalized and approved by our directorship. We'd be happy to give the committee a copy of that once it's available. And we also have a new portal, online portal, where debtors can go on to view account details and make payments. I do have some slides on that I'd be willing to show, if you'd be interested.
Yes, we would be interested. to do anything.
Sorry. Oh, there we go.
There we go.
So once a debtor logs in, here's the home page there. They'll put in some pieces of information to look up their accounts. Then here's the first page that they will see. Just give some basic account details as required by the statutes in HB 216, including the interest rate they're being charged, the current amount due. Gives them an option to make different size payment rather than paying the full amount if that's not what they wish to do. Also at the top here gives the total amount due and also says the total payments received to date. And then there are a couple buttons they can push up above with details and see payments, as you can see. One of them will take them to, this screen. This is the payment screen, basically. This actually shows any charge or payment that has been made to the account. And it breaks down very specifically how that payment was applied. As you can see, the 4 highlighted rows there, or the rows with the arrows next to them that I put, shows that total payment was $2 and exactly how that was split up between fees, administrative costs, interest, and principal. Then there's another screen where it gives them the original amount that was referred to my office for collection, as well as the current balance, the type of obligation, and who the creditor essentially is, whether that money is owed to a victim, say for instance, or to the state agency, or to my office, OSDC. My office is also working with the state courts. We just recently completed an RFP to give some payments, additional payment options to debtors who may not have a bank or may be underbanked. This includes the potential for walking into a 24-hour retail location such as Walmart or Walgreens or something like that, with the ability to pay their bills there, as well as the potential for kiosk locations. We're still looking into that as well. And it would expand these payment locations, being the nature of it, into rural areas as well. So currently our payment options are pretty limited. Of course, our office is only open normal business hours. And so this would help those debtors that don't have banks or credit cards or so forth to be able to make payments more easily. So that's about all I had today. So.
All right, thank you so much for your presentation, Mr. Bowers. I don't see any questions from the committee. Okay. So appreciate your work and debt collections. I know that helps us pay the bills and keep the lights on, so appreciate that.
Thank you, appreciate the time.
All right, we're next going to hear from Representative Candace. If you'd like to come forward, Representative. I know if anyone has any leftover Chinese food, she'd be interested in that. That's a bad joke.
Oh, man. I apologize, Mr. Chair. I'm on week 3 of a sinus infection. I've been assured by 3 doctors it is not contagious. I feel like death. So I'll be brief, really, but appreciate the committee taking time on this. Since the last session, I had a chance to meet with Paige and TU2O, who will be here and also is here if there's room for public comment, and if not, I'd love to give some of my time for him to speak to his experience. But I was really surprised, he was a former incarcerated individual who is now working, hardworking member of society and paying his taxes. And he was surprised to receive an additional invoice after he thought he'd already taken care of what needed to be paid. And I've shared this with Jonathan prior to the last session and during the last session as well, some of those invoices. But what was most concerning to me about that conversation was he said that as he's talked to other members in his community who are formerly incarcerated individuals, that they found that it was once they had got a job, were working hard, paying taxes, that they then got pinged with this nasty invoice and the amount they owed. And the comment was made, an individual said, if I wanted to go back and sell drugs and work under the table, those people are not getting hit with this same invoice. And to me, that just showed that the policy is having a negative incentive. We want to be incentivizing people to be working above board and contributing members of society, right, as we work towards rehabilitation. And so I have appreciated Jonathan digging in on this. I know we have had some moving pieces of legislation since talking about it, but I did want to bring this up, and they're here to speak to that specifically to ensure that what we are implementing up here is hopefully what we're seeing on the ground, to where these individuals feel like they actually are able to get back on their feet and we're not smacking them down again after they've tried to do the right thing. So Paige Norton, has had an opportunity to work with a lot of these individuals. She has a couple minutes, and then, like I said, Mr. Chair, I don't know if you're gonna allow for public comment on this, but if not, I'd like to allow these individuals who have come up just a few minutes to speak to it.
I was planning to allow for public comment.
Thank you, I appreciate that.
Hello, thanks for having me. I'm Paige Norton. I'm an advocate for prison and criminal justice reform. There are at least 3 ways that an individual can be charged with restitution. There's the court-ordered, and then medical charges that are incurred while a person is incarcerated. And then a third way is fines from write-ups while they're incarcerated. So while a person is incarcerated, if they receive a write-up from the Department of Corrections, that write-up often comes with a fine. To me, this is the most concerning of all. If the Department of Corrections is utilizing write-ups as a source of revenue, then this one practice could be a huge contributor to the culture within the prison system and the mass hopelessness of those incarcerated and their families. If the Department of Corrections staff is looking for reasons to write up inmates because they depend on this revenue source, then it's very easy to see why inmates feel like the Department of Corrections is trying to make them fail. Inmates are being written up for this or that, and therefore adding more and more write-ups to their record and more charges to their restitution. One thing that I think we need to, that needs further review is the topic of interest. I have yet to meet an inmate that isn't being charged interest while they're incarcerated. The case that initially brought restitution to the forefront of my attention is that of Suluka Taliaias. He is currently incarcerated, has been for over 20 years. Every month for 20 years, his inmate statement showed that he owed $0, including the statement that he received November 29th, 2021. Exactly 1 month later, he received a letter stating that he owed over $34,000 to the Utah Office of Victims of Crime. Less than 4 months after that, he received another inmate statement stating that he owes over $63,000. How would you feel if you were in his shoes? As people are looking into this restitution situation, I would recommend they drill down on the following questions. Number 1, how are the court-ordered amounts for restitution being decided? Number 2, why are inmates being charged fines for write-ups in prison, and how are those amounts being decided? Number 3, who is overseeing the accuracy of medical charges a person receives while incarcerated? Number 4, why are inmates with almost no ability to repay a debt being charged interest? Number 5, why are inmates being told for decades they owe nothing, then being hit with gargantuan bills? Because I can guarantee you that Mr. Taliaia is not the only one in this boat. And then finally, when a person is released and finally in a position to pay their restitution, I'm glad to hear that there are new options for repaying their debt. A sliding scale similar to those that are utilized for child support payments is a really great idea. But requiring them to pay enormous monthly payments not only seems egregious, but it almost forces people back into a life of lawlessness, as Representative Perucci stated. I want to thank you for your attention in this, and I'm grateful for Representative Perucci and for her willingness to take this on.
Thank you. I have a question. I know it's anecdotal, but with Mr. Taliaia's experience, how was the 34/63,000? Did anybody dig in and find out where those charges came from?
There's no explanation given at all. In the letter that he received, it's a letter, it's not a form, and he has no idea. He was not given any explanation.
Who's generating the letter?
The Utah Office of Victims of Crime.
Okay, and do we have any indication how much of that may be interest?
No.
Okay. Okay.
But then the thing that's interesting is the one that he received a couple of months later was not from the Utah Office of Victims of Crime. That was his inmate statement that went from $34,000 to $63,000.
Okay. Representative Perucci?
All I was going to add is I am eager to see the transparency that seems to be coming through this portal. Some of the invoices I looked at, again, it was surprising to see the amounts and where they were coming from. And the most recent one I saw was in 2022 with one of the individuals who I think is going to speak today to this.
All right, thank you.
Thank you.
I'm sorry, can you stay? Representative Lisenby.
Thank you, sorry. So, listening to your testimony, I've had a couple of conversations on this, but actually, I think that some of what you're talking about was addressed in 216, but I think that that was addressed, it barely just is coming online as a law, and then it was addressed in a forward-looking policy way. So I think some of this has already been addressed. So I think, actually, I may retract that and say this might need to go through the working group, just because what you're suggesting, these changes, would actually touch a lot of the policy areas where there has been discussion over the past 3 years, broad discussion and deep discussion on this issue. And I'm a little concerned that trying to just one-off this might actually cause more problems than we're helping, just because we've actually tried to address a lot of these things already. But I'm interested to hear the testimony. I can't speak to those specific cases, but I'm interested in hearing from them and in looking into this further. Thank you.
Thank you. Okay. By a show of hands, are there members of the public either here in person or virtually who would like to speak on this bill? So I've got 1, 2, 3, 4. Any online? Okay, I'm going to set a timer for about 2 minutes because we do have a special session this afternoon. Please come forward. We can fill both seats up. Please tell us your name and tell us if you're here representing yourself, that's fine. If you're here representing an organization, let us know that as well.
Good afternoon. My name is Ricky Zazueta, and I'm representing the people. My name is Ricky.
Hey, we have that in common. We represent the people too.
Yeah. My name is Ricky Zazueta. I served a 7-year sentence from 2012 to 2019 in the Utah State Prison. While incarcerated, I received my high school diploma and a culinary arts degree through the prison's college course program with Davis Tech College. So with me, your tax dollars were not squandered. Since being released from prison, I've successfully completed parole in 2021, and utilizing my culinary degree from prison, I've embarked on a great career as a private chef / certified personal trainer at one of the greatest rehabs in the country, the Renaissance Ranch. Being able to make an impact in the lives of men who've suffered from the hardships I've endured has truly given my life lasting purpose. While incarcerated in the Utah State Prison, I've kept a job working for the state as a prisoner, working 8-hour days, 5 days a week, getting anywhere from $60 to $120 a month my whole 7-year stay. Not once on my OSDC state-issued monthly statement did it ever say I owed any restitution. Am I saying that I don't owe restitution? On the contrary, what I am saying, due to recurring interest, late fees, and other fine print chargeables that was accumulating while I was incarcerated, the sum of what is now owed is so beyond measure, I will possibly have it fully paid off by the time that I'm 50. All because I wasn't given the chance to pay towards it while I was incarcerated. If my statements had reflected that, I sure would have been paying towards it my whole stay. But the opportunity was taken from me for whatever reason, either through negligence, human error, or just an outright ploy to rack up as much funds as possible, which I hope is not the case. I am now an extremely productive, tax-paying member of society who is trying to progress financially in life for my wife and children, so you can understand my frustration when out of nowhere my check was garnished for $700+ and continued to be garnished for several $100s each month following. The state garnishes my checks every month for funds that could have been drastically reduced if I was given the chance to pay monthly while I was working in prison. Again, a chance that was taken from me. In closing, I would like to say we are in a society where money and credit is going to determine whether our kids live in a good neighborhood, attend a good school, and potentially become great productive adults in their world and be able to break generational curses for not only our kids, but for their kids and the ones to follow. So I ask you to please make it right and allow our children to potentially be able to attend a good school, live in a good neighborhood, and be put in the best possible situation us as parents want for our kids. A potential bill will not only change the lives that are here today, but more importantly, the many lives and families to come. $500 a month may seem a minute amount to you, but to us, to all of us, it can be the determining factor of where our children live, what they eat, what they see, and what they are potentially subjected to. Thank you.
Well, and I want to thank you for being here. I think it's very helpful for us to hear from someone who's personally experienced it and put a face on that. I also want to thank you for not only using your time in prison productively, but also for getting a job and doing what you're doing, because I think I don't know you, but you strike me as a success story. I think all of us want someone who gets in trouble to serve their time and come out and be a productive citizen. So congratulations on that, and hopefully we can get to the bottom of this. If you don't mind me asking, and you don't have to answer, how much was your balance?
So my initial restitution was $18,000. When I got out, it was in almost $30,000. It was like a little over $25,000.
That's helpful. Okay.
So like I said, I understand I owe restitution.
Yeah, yeah.
Just all the interest and all that. I could have been paying towards it while I was in prison. And it's something that's going to affect me and my kids and for years to come. So.
Sure, understood. All right, thank you, sir.
Thank you so much.
Please.
Thank you. My name is Amanda Montague. I'm with the Attorney General's office, and I'm here because I'm part of the restitution working group and also because I represent a number of these agencies, specifically Office of State Debt, Utah Department of Corrections, and the Utah Board of Pardons and Parole. I first would like to advocate, as Daniel Strong did, that these matters go to the restitution working group. This is a very complex issue and things that we have been discussing for several years now. Office of State Debt would like me to make one point that Mr. Bowers forgot to make, which is that they will go live with this system to allow people to access their debts on June 19th.
This year?
This year, yes. So in just a little over a month, they'll be prepared to go live with that. I also wanted to address a little bit about some of the comments that have been made and just say the previous presenter is a lot of the reason why we sat down as a working group to try to resolve these things. I think everyone was unhappy with the system that allowed someone to receive a restitution order basically at the end of their sentence, have no ability to pay it, and then have additional fines and fees added on when they had had no opportunity to make that right. And a lot of this was addressed in 2021 with Representative Lisenby's bill, HB 260. The difficulty is that we were not able to make that retroactive. And so you have a number of individuals who are still under the old system that are processing through. And there may be ways to alleviate that we'd like to look at in the working group, but it's very difficult to go back and change the system that they were under. But we have tried to work through this so that similar things don't happen to people going forward. Thank you.
So let me just ask you, with the IRS, when people get in trouble, I know from listening to KSL, you can hire Jordan Wilcox. I don't know Jordan Wilcox, but he'll negotiate for you and get that, But we know that the IRS will allow payments, like a bulk payment of a percent and then write off the rest. The state of Utah, we don't have anything like that, do we?
The Office of State Debt does negotiate with debtors,
Okay.
certainly. I think one of the difficulties is when you have victims who were harmed, unless the victim agrees to a settlement, Office of State Debt will not negotiate away that victim's portion of the money.
Okay.
But Office of State Debt certainly will negotiate with individuals, particularly if they're willing to make a large payment up front
Okay.
to reduce some of the fines.
And is that a new policy, or has that always been the case?
I think that's always been the case, but I do think, and Representative Lisenby apparently knows too, so I'll let her answer.
Representative Lisenby?
I think we reiterated it in 260, but it was
Yes.
a policy. but
Okay.
we just-
Okay, great.
Yes.
Thank you for your testimony.
Thank you very much.
All right, we have a new face here. Would you like to introduce yourself, sir?
Yes, you may not recognize me. My name is Will Carlson.
Oh, Mr. Carlson, I thought you looked familiar.
I'm with the Salt Lake County District Attorney's Office, and the DA's office would encourage the Interim Judiciary Committee to send this issue to the Restitution Working Group. There are some really valid concerns that have been raised here. For example, interest rates. Last month, I received a 402 reduction motion where somebody wanted to reduce their case conviction, but they had had a restitution order sent to state debt in the year 2000. At the time, it was $35,000 that they owed. And so I called OSDC and said, how much do they owe? And they said, they owe $46,000 now. So that defendant owes more than they did at the time that they were sentenced. And even though they were very successful on probation, they haven't even been able to keep up with interest. And that's sad and unfortunate. However, that restitution wasn't for the defendant's medical bills or for transportation costs for the defendant. That was loss that the victims of a violent crime incurred. And when that judge ordered restitution, that victim got a property right interest in that restitution amount. And this committee should be very hesitant before they decide to take away that property interest from crime victims, especially after a court has ordered that restitution. You certainly could, but before you take those steps, I'd encourage you to make sure that the stakeholders involved in the restitution working group all work together to come up with a recommendation for this committee. And so I would recommend caution on this issue.
Thank you. I'll just add that before we go to the next presenter, I've had personal experience with a client who was a neighbor of mine where the interest was so high. For free, I took him back to court and tried to get the interest reduced 22 years ago. And when the judge stopped laughing at us, he said no. But in that case, the interest was so high that he had no incentive to pay it. And so he said, look, if I can get the interest rate either waived or lowered, I'll make monthly payments. But he just had no incentive. So instead of the state and the victims collecting something, he's just paying nothing. And it's hard for me to blame him because he couldn't even afford to keep up with the interest because he had stolen a lot of money. And I don't have any, I'm not making any excuses for him, but it seems like if we incentivize someone to pay nothing, it's not working.
That's a problem as well, yes.
Okay, thank you. Please tell us your name.
My name is Tiu Wow, so I guess I'm just here to pile it on.
Okay, please do. Go ahead.
Good afternoon. My name is Tiu Wow. In 2010, I was released from the Utah State Prison after doing 7 years for aggravated robbery and assault. In those 12 years I was released, I met my fiance. We had 3 beautiful kids, and I got a job at this company, Tempest Enterprises, natural gas. They gave me a fair shake, gave me a shot at it. And when it comes to natural gas, we did it for Dominion Energy. Natural gas pipeline, I'm the best in the business in this state, hands down. And I'll tell anybody that. About a decade ago, I started getting letters regarding the restitution I owed. At that time, it was over $60,000. I called the number to try to work it through. The lady that I spoke with, she told me if I don't make a payment at least $600, I'm not even catching the interest. So there was no way I could afford it. I continued to receive letters. And in 2022, I received a letter from Mountain America that the state was trying to put a lien on my truck, but they couldn't do it because I didn't own it yet. So it backfired. But at the end of the day, 100% I take responsibility for my debt. It's mine. I know I did it, and I owe it. But for what they were asking, couldn't pull it. Not with my kids, not with the economy, and like the consequences. The house that me and my wife live in, I didn't put my name on the house because I didn't want the state to try to take it. When we file our taxes, I'm always worried about that. I'm always worried about my wife having to eat what I did. That's mine, and I owe it, and I do it by myself. And as far as consequences, I remember like as a juvenile, my dad looking forward to buying this truck, and he couldn't get it because the state took that money from him, and he was mad at me. He's over it now. But this crime happened so long ago that the money that keeps stacking it on, like that, the victim, I'm sorry. But to say she was leaning on this last $18,000 that I owed, that's like 20 years ago. She's past that $18,000. So the $71,000 I owe, where did that come from? Facts. Like when I got out, I owed so much money, it was crazy. And my first job, any inmate that gets out, he's more than likely he's gonna get a low-paying job. I was making minimum wage when I first got out. I couldn't make a $600 payment, no way. And when I talk to these people on the phone, they treat me like a criminal. So if you keep treating them like a criminal, they're gonna act like a criminal. The dude is trying, I was trying. Lucky I met my fiance and she didn't give up on me. I'm rambling now, but I really feel passionate about these dudes that when they get out, they need a chance. So when they get out and they have all this debt that gets dropping in their lap, man, they need everything, they need all the help. So when they get this drop in their lap, it's so easy for them to give up. And we're out here, we're trying to help them. As soon as they come out, we're trying to get them jobs. I've had them on my crews. I've had them in the middle of the night laying this high-pressure pipeline, grinding it out, always in their ear to keep trying, keep pushing. But at the end of the day, you know, we just need help. They need help. I'm good now, but yeah, we do need help, and the system needs to get fixed.
Well, again, thank you for becoming a productive member of society. Thanks for creating jobs, and thanks for giving ex-cons a second chance. I think that's really important. And let me just tell you, Representative Lisenby passed a bill just this year that makes sure that when before someone's released, that they have a birth certificate card, so that the day they get out, they have the paperwork, so someone like you can hire them. So, you know, that's what we're trying to push from our side too, to help people get out and get to work. Representative Lisenby, did you have a comment or question?
Just that I had a lot of help from Senator Weiler.
That's not true. Okay, but your light was on before, or was it Representative Birkeland?
I do have a question, Mr.
Yeah.
Chair, and I don't know, I love these stories, and I think this is exactly what the problem we want to solve.
Yeah.
Is it Representative Perucci's hope that we move this into the task force? Just as we hear these stories, it to me seems like, of course, we're going to address this.
Yeah.
I just want to be clear on how.
If only Representative Perucci were here. Oh, she is. Can you let us know?
I apologize, Mr. Chair. I didn't want to hack along on the
Yeah.
committee. I had brought this was something that Jonathan's been working months and gathering research on, and wanted it to be brought to the expert to this committee as something, if it was something you're already working on. I also have been texting Representative Lisenby about this, and it's something that I think we could work through as well. So I was hoping that it would stay within the committee as a follow-up. It seems like the piece that we've identified is, while we have passed legislation, there's this level of retroactivity of people who are getting out of the system that it didn't apply to, and would love to continue working on that.
All right, thank you. We have a few other comments or questions. Representative Malloy?
Thank you, Mr. Chair. I have two quick questions. The first one is, what kind of interest rates are we looking at on these restitutions?
Jonathan, can you field that one?
Sounds like it's really high.
I can't, unfortunately.
Okay, Representative Perucci?
All I was going to say is, if with the permission of these individuals, I'd need to, and I could clear their name. A lot of these invoices have been shared with me, and a lot of them are pretty high, and if they're okay with it, I'd get their permission and I could share with you some actual hard copy examples.
So
But who's setting that, I think, is the
Oh,
question.
they're coming from different places. Yours was what Paige said. I think one was debt collection, the other was victim services. They're coming from different entities.
Do they have different interest rates, or how's the interest rate set?
And I'd have to go back and look at the actual numbers. I should have brought them with me today.
I will say, if there's a civil judgment, we have a statute that takes the prime rate on January 1st of each year and adds 2%, and then that's the legal rate of interest for that year, but it can change every year. Am I saying that right, Michael? It's same for criminal judgments. Okay, so it's probably that's where the interest rate's coming from. All right, we'll next go to, is that you? Oh, go ahead, please. You did say two questions.
And this gentleman here who spoke earlier, it sounds like he was willing to pay at least interest payments while he was incarcerated.
If he had the chance.
If
yeah.
he had the chance, and it sounds like he had a job in the prison system. Is there anything preventing him from doing that? Do we know?
Well, I don't want to speak for him, but I think it wasn't showing up on his account. My guess is that this new website from the debt collection would help, although I'm not sure a prisoner would be able to access that website, so, while in prison.
That job is only 40 cents an hour.
Yeah, yeah.
I know it's
To your point, though, they didn't even know about it until after, and they were aware of the restitution amount to the victim, but it sounds like a surprise bill where they get it and then they're unaware of it.
Seems like if he has the ability to put a few $100.
Exactly.
to
I
be
mean,
able to
with
do that.
interest, anything's, yeah.
Yeah, okay, thank you.
All right, thank you. We'll go, is it you, Representative Acton?
Yes, thank you, Mr. Chair. I'm just really fascinated. It's so helpful to have people who have experienced the things that we're talking about. So thank you for coming. Very empathetic to the financial stress that you must be under and have been put under. But I wondered, is there any mechanism currently in law to forgive a debt? Do any of these entities ever, or victims ever say, I don't want the 18,000, for example, that you just talked about?
I think Jonathan had dug in on this a little bit.
Yeah, no, it's my understanding, and this is something that appeared in HB 216 back in 2021, that a victim can consent to the remittance of unpaid restitution debts.
Or partial
But-
payment.
Or partial payment, yeah.
If I may, Mr. Chair, it's just whether that applies and how far back we're going, right?
Yeah.
So you have people who committed crimes in the past that they're paying for now, but if 216 doesn't apply to them, then the behavior is not being changed. So it may not apply.
Okay. Real quick, we'll go to Representative Lisenby.
Thank you. There's a lot to unpack here. Policy that was in 216 does apply actually retroactively. So if a person is currently in the system, whether in the old lane or the new lane, they could have their debt forgiven by the victim. Yeah, I'm getting, yes, shaking of heads. The other issue is that previously the orders weren't finished until the individual was, and maybe actually Amanda has an issue to that question. She could probably verbalize it better. So let's, if it's okay with the chair, maybe she can
Yeah.
just answer really quick the
Please come back forward.
previous
Tell us your name again. Thank you, sir, for your testimony. And thanks for being the best at your job. Appreciate that.
I'd like to say that I'm also almost the best at my job. Very good. Amanda Montague again. I just was telling Representative Lisenby, a lot of what was happening prior to the changes in 2021 was that a court or the Board of Pardons could impose a restitution order up until the date that a person's sentence ended. And frequently that's what was happening. The Board of Pardons or the court would put that off until the very end. And so frequently there wasn't a number to start paying while a person was incarcerated because no order had entered.
Thank you.
Are there other
Well,
questions?
and there may be other questions, but I just wanted to just weigh in. I know that there's a desire to keep this, and I first verbalized that I thought it was super narrow and would be appropriate to keep in the committee. This is touching on a lot of spaces that I'm not sure that we'd be able as a committee to really justify keeping it here. I don't think, I think what would end up happening is you would end up having a working group during this session when everybody's under a lot of stress with a lot of different stakeholders weighing in and having concerns. And so I'm wondering if it would just be possible if the working group would commit to working with Representative Perucci, and I'd be happy to also be there and help and make sure that the interests of the committee are represented if the committee feels comfortable doing that. But I think that this is appropriate based on the conversation that has developed through the hearing, that we refer this to the working group. That's just
Yeah, I would agree.
something that I think is really important, that we make sure all stakeholders around the table have a voice.
Yeah, thank you.
You're welcome. And I won't say that I can speak for the working group, but I do believe that we would be committed to discussing these issues. Certainly, we have discussed whatever issues the legislature has sent to us.
Can you tell us real quickly who is on the working group?
There's a number of people on the working group. Daniel Strong is now sort of our leader. Mike Drexel is there. I'm there. People from Office of State Debt, people from the Board of Pardons, people from the Department of Corrections. Mr. Moffitt is on that group. Will Carlson is on that group.
You have any legislators?
Representative Lisenby.
Okay.
And then Utah Office for Victims of Crime has representation on that committee as well. And then we have some victim advocates.
Okay, thank you.
Sound okay?
Yeah. Okay, are there any other public comments? Anybody else who raised their hand that we haven't heard from? Okay, we're going to close the public hearing and bring it back. So Representative Lisenby, would you like to make a motion? One of our options is no action. One of our options is to open a bill file. I don't know if we have technical authority to refer this to the working group, but I'm sure you can make that part of a motion if you want.
Thank you, Mr. Chair. And let's see, you can correct me if my motion is terrible, but I think what I'd like to make the motion to do is, first of all, thank you, Jonathan, for all of your work and research on this issue as well. This is a huge issue in Utah, and we do want to make sure we get it right. So my motion would be that we do open a bill file as a committee, but refer the actual bill file to the working group in conjunction with Representative Perucci and myself to ensure, and anybody else who I guess wants to be part of the conversation, to recommend changes and bring those back to the committee at a later date.
Okay, we have the motion before us. Just for clarification, once we have a bill file, the chairs usually decide in November who to assign the bill to. We can only assign it to a member of the committee, so we could not assign our committee bill to Representative Perucci, who's not on our committee. Just with that clarification. So any discussion to the motion? Seeing none, all in favor say aye. Aye. Any opposed? Chair rules that passes unanimously. All right, it's 3:10. We've got one more major item. Thank you, everyone. You're welcome to stay. We'll hear a presentation from staff, starting with Mr. Adams, and then stakeholders on victim offender mediation programs, which aim to bring together victims and offenders to address harms caused by the crime. So we'll kick this off with Jonathan.
Great, thank you, Senator Weiler. I'm going to be really quick. I know that we've got limited time. So before we turn it to presenters to speak to victim offender mediation programs, I wanted just to give some context to a concept that's related that I think is important to understand going into this conversation, and that's restorative justice. So this concept differs from maybe more traditional or punitive or retributive forms of justice in that restorative justice sees crime primarily as a violation of personal relationships as opposed to an offense against the state. And as such, restorative justice models and programs are focused on addressing the harms caused by crime and restoring victims versus punishing the offender. And this is a concept that can really trace back to a lot of indigenous communities, but really kind of developed and gained steam in the 1970s when it was popularized as a tool in criminal justice reform. Today, it has been adopted to varying degrees. I found a 2020 50-state survey that looked at the extent to which different jurisdictions have implemented, to varying degrees, restorative justice concepts and programs. And as of 2020, at least, there were 45 states and the District of Columbia that have adopted programs like victim offender mediation. And you can see here from this graphic that Colorado is the one that's kind of been the leader in the restorative justice space. Utah also has some relevant laws in this space. So for example, Utah utilizes victim impact panels in cases of like a DUI offender, to have them understand the consequences of their actions. So Utah also does implement some of these restorative justice policies. And the most common restorative justice program are these victim offender mediation programs that we'll hear more about from our next presenters.
Okay, thank you. Our first presenter will be Steve Burton from Intermountain Legal. And then are you David? And then we have David Ferguson, who's the Executive Director of the Utah Association of Criminal Defense Lawyers. So Burton changed his mind. Oh, no, he's coming back. All right, Mr. Burton.
Thank you. Yes, good to see you all again.
Just go ahead and introduce yourself.
Steve Burton. I work with the Utah Association of Criminal Defense Lawyers and represent defense attorneys or a defense attorney association in legislative issues. I was made aware of this issue several years ago when I heard a story about societies in Kenya where when somebody was injured or harmed, the clans of the injured person and the person who committed the injury would get together and confer, and they would discuss what an appropriate and fair resolution was, and then they would consult with the members of their own clan and try to find a resolution that they all felt was fair and just and the best resolution. And I thought, man, that is really fantastic. Is there any way we can implement something like that in Utah's criminal justice system? And when I had mentioned kind of this idea or the concept to my friend David Ferguson, who's our executive director, he said, well, yeah, there are lots of states that actually have victim offender mediation programs or laws on the books. And so then I started mentioning it to legislators, and every legislator I mentioned it to said, you know, that is a really great idea. We should look into doing something like that. And so I was really glad when the committee decided to make this an interim study item. And what we'd like to do is David is going to discuss exactly what that means, and then I'd like to discuss how we might apply that in Utah's criminal justice system.
All right. David, can you also introduce yourself?
Right, David Ferguson, Director of the Utah Association of Criminal Defense Lawyers. So most of what criminal justice is negotiating plea resolutions. Usually the defendant is interested in taking responsibility of some kind of conduct, and there is some consideration about what is the appropriate penalty. This ends being discussions for exactly what should be the right outcome. And discussions oftentimes involve parties who are interested in resolving but can't quite get to a resolution. And what happens is, very typically, is they put a pause on things, they come back to it later, cases stall. This is why cases sometimes go 2 or 3 years, because they can't quite get to that last final push. So what happens is, at some point somebody loses steam. It might be the prosecutor, it might be the defendant, it might be a victim who has strong opinions but decides, look, I just want this done with. Somebody loses interest and eventually concedes something, and the case resolves, which can be good because the case resolves, but somebody feels like they've kind of lost out on some justice in the process. What mediation does is you essentially get these individuals, these groups, into different rooms with a mediator who is a neutral party and has the benefit of being both, in some sense, an advocate for everybody while being a neutral party for all of them, and gets them all to, goes back and forth so that each individual can talk to the mediator directly. The mediator can present positions to the other people, can try to see how they feel about it. This can get communicated back. And what you can do is in just maybe 2 or 3 hours or 4 hours, you can resolve a case that would otherwise take 3 or 4 years to get to resolving, just as it goes on its normal track. So it has a lot of support in other states because of that, and Mr. Burton can talk to more.
Yeah, so I was thinking of how we could use it in Utah's criminal justice system, and wanted to give an example of a case that I was involved in personally, where right after we got married, my wife had informed me that she had been saving some money in a shoebox in our closet, and asked me if I had taken any money out of the shoebox in the closet. And I said, no, I didn't know we had any money in a shoebox in the closet. But she hadn't told me because we weren't married for very long. And she was still, I think, feeling things out. But money started going missing from the shoebox. And we eventually installed some cameras in our home and found out that it was one of our neighbors. And that neighbor had been coming into our house and stealing money from us. And this was shocking to me as well, but it ended up being more than $10,000 over the course of several weeks. And when we reported it and they charged this person with burglary, that case went to court, and the prosecutor was negotiating with that person's attorney, and they were negotiating in a way that would have required some substantial penalties and would not have gotten us our money back anytime soon. And luckily, because I'd been involved in the system, I said, no, listen, we can do something better. The most important thing to my wife and I is that we get our money back, and we don't care that this person has to serve some jail time or has to have a conviction on the record. And so luckily, from some pressure from us, we were able to work out a situation where they paid us back in one lump sum, and we were able to take that money and buy our first home as a married couple. But that only happened because I was familiar with the system. I was able to push in the ways that I needed to push. If there would have been something like this victim-offender mediation, that could have probably been worked out in a couple of hours. As David mentioned, it gives an opportunity for the offender, through a mediator, to communicate with the victim in a confidential way. Those communications cannot be used later at trial, so the offender can talk much more openly and agree to things that they wouldn't normally agree to. Because
And
that
again,
might
they're
be a
usually
victim.
not in the same room, so they're not like staring at each other. So-
Right, yeah. And as Senator Weiler pointed out, this is something that's very often used in family law cases. Most cases are resolved outside of having to do a trial. And in those cases, actually, the law requires them to make an attempt to mediate those cases because they found out that it can be so effective in highly contentious situations. I had another case where I represented a co-defendant who had invited a girl over for a date, They had done drugs together, and my client's roommate said, that person stole from me. And she said, no, I didn't. I don't know what you're talking about. And the roommate was so angry that he got a gun and he told my client to tie the other person up. And then later, when that person was trying to escape, my client's roommate ended up stabbing the victim. They were both charged as co-defendants. And when we went to court, I should say this, my client couldn't even look at the pictures of the injury without feeling sick. He was sick to his stomach about what had happened. He asked me multiple times, what can I do? How can I make things right? I can't believe this happened. How did I get myself here in this situation? And he said, what do we even say to her? And I said, don't say anything to her when you see her in court. Don't stare at her, don't glare at her, don't frown at her, don't scowl at her. Just acknowledge her and give her a pleasant look. I later found out that the main perpetrator's family had reached out to her and said how sorry they were and that their son is really a good person and they want to make friends and see what they can do to support her. So they had interacted with her kind of in this way outside of the court system. But because my client wasn't able to communicate while this case was going on for more than a year, I found out later that the victim thought that my client was smirking at her. And so she forgave and experienced healing in regards to the person who actually did most of the injury, and she felt continued harm and anger against my client who had told me that he wanted to make things right, but never had the opportunity to communicate that to her. So again, this is an example of how a victim offender mediation could be used in order to facilitate that communication. Let the victim understand what the offender's position is, what they truly want. Give them an opportunity to apologize without admitting guilt and putting themselves in the worst possible position. So there's a lot of potential benefits to using this type of situation, and there's a lot of states that have already tried it. As was mentioned in Jonathan's presentation, we've looked at examples from Idaho, North Carolina, Kentucky, New Hampshire, Maryland, Delaware, Alabama, and there's little variations. And so I think that our hope is that this committee would look into the possibility of instituting some kind of victim offender mediation in Utah. And there would be decisions of how exactly to do that. For example, we'd have to decide if this was completely established in statute or if we wanted to let the Supreme Court establish it in court rule. That's, for example, what Idaho does, is they established it in court rule by their Supreme Court. Also, we have to decide if who has to agree to the mediation. Can somebody be forced to mediate, like in a divorce case, or must all parties agree to do a mediation? Our personal suggestion, or our organization's suggestion, is that we probably should go that direction, because then those jurisdictions who feel like they want to try it out, if everybody's on board, they can try it out. Those judges or prosecutors who feel like they don't want to do it, or defense attorneys who feel like they don't want to do it, they don't have to do it. So we see it as an extra opportunity without necessarily making it a mandate right off the bat. Other decisions would have to be made. For example, do we want to use this in just misdemeanors, just felonies, or all types of cases? There's some research talking about how it's more effective actually in violent crimes or more serious felonies rather than misdemeanors. So these are decisions that would need to be made. I don't know. If this committee has interest in those things, we would hope that those would be details that could be worked out and brought back to this committee as a potential bill for the session. I do want to give just a few pieces that were from studies that were done on the effectiveness of victim offender mediations. A study in 2022 said that offenders participating in victim offender mediation reported feeling increased guilt, regret, moral failure, and responsibility for their offense, as well as increased empathy for the victim. And I think that that's really our goal, was we want offenders to recognize the impact that they had, take more responsibility and feel a desire to resolve that case without creating kind of an all or nothing, guilty or not guilty type of situation, black and white situation. Another study from 2020 showed how the victims reported greater satisfaction after going through mediation rather than traditional court proceedings. Victims reported outcomes as being more fair and just. Victims were more likely to receive reparations, financial or otherwise, by going through mediation. And that was the study who also found that violent offenders were actually it was more effective with those types of cases than other types of cases. So we are very excited about this possibility and hope the committee is too.
Thank you. I just have one question. Where does your wife keep the shoebox?
It was in the closet.
I was just kidding.
It was in the closet, but before we could get it into the bank, after we noticed the money was missing, that was when the bulk of it was taken.
Okay, thank you. We may have a serious question for you. Representative Birkeland?
Yes, thank you, Mr. Chair. I am very much in line with you on this. I really like this. I did have a question which you kind of answered. I have concerns about violent crimes. Have you talked with victims groups, or do you have information from other states as far as when it is a violent crime? I mean, to me, it seems like it would have to be, everyone would have to be willing to come to the table, not mandated to come to the table when there's a victim of a violent crime in this situation. Can you speak to that at all, if that's how other states are doing it, or your preference to that?
Yeah, add anything that you want. We have found that different states do it differently. Our suggestion is that if Utah starts with a completely voluntary program, literally everybody has to be on board. So it's only if the victim wants to do it and the accused wants to do it and the judge thinks it's worthwhile and the prosecutor says it might be a good option in this specific case. There are some states that actually have some sort of compulsory process in misdemeanor cases, but I think that the majority of states require that's just a voluntary process.
So one state that does this a lot is Idaho, and I had a conversation with a former district attorney in Idaho who talked about specifically in violent crimes, sexual assault crimes. And one of the things that she found was that victims really liked about it was our adversarial system really only gives a victim a chance to speak at 2 or 3 different times ever to relay like their feelings and frustrations about the case. And it might be at a bail determination, but otherwise it's only at the time of plea or sentencing. And this allows the victim to have far more direct input early on. And so she found that she really, as a prosecutor, she really liked it because she felt it was empowering to victims to be able to do that. And then victims could release some of the emotion, the strong emotion, could also, feel heard, and then there could be a little bit more reconciliation from that.
Another question, if I may, Mr. Chair?
Yes, please.
Thank you. How many states did you say have a process like this? Do you know?
We don't know the total number. The ones that we had looked at kind of more specifically were Idaho, North Carolina, Kentucky, New Hampshire, Maryland, Delaware, and Alabama. I think there are more that we didn't.
And let me just throw out there, I looked into this issue about 1.5 years ago because there was a bill in the Senate that didn't go anywhere, but I was asked to research it. But I was surprised that there was a combination of red and blue states. It wasn't like this was a Republican idea or a Democratic idea. It seemed more like it was a bipartisan approach. So,
that's what it looks like from.
for instance,
states
Texas has implemented it, I know. So, and you've mentioned Idaho. So, any further questions? All right, thank you. Let me just ask by a show of hands, either online or in person, if there's members of the public that would like to be heard on this. So we have 2 and 1 online. So we'll thank you. We'll start off with Ms. Oldroyd online, and Ms. Oldroyd, we'll need you to turn on your camera and to tell us we don't need your address, but we need to know where you live, like what city and town you live in. That's our new rule for virtual testimony. So Ms. Oldroyd? All right. All right, Ms. Oldroyd, can you turn on your camera? Thank you. Okay.
Hi, thank you, Mr. Chairman, and thank you for an opportunity to address the committee. I am a mediator in the community and would just simply like to lend a bit of comment about the skill set required of the neutral who would be serving in this capacity.
Okay, before you do that, can you tell us your full name and what county you live in?
Absolutely. I'm a resident of South Jordan in Salt Lake County. My name is Michelle Oldroyd. I'm also a bar member, so I appreciate the lawyer legislators who are serving on the committee as well as doing service to the bar.
Thank you. All right, please proceed.
Thank you. Sure, I'm happy to lend some input. I just simply wanted to express that I believe that mediators who serve in a victim offender context would need to have very specific training. We would want to ensure as a mediation community, for example, that there was not secondary trauma to a victim for participating, that there was requisite planning and purposeful design of the mediation process, such that the mediator could not only be an effective neutral and convene dialogue that's meaningful both in separate contexts with the victim and with the offender, as well as potentially joining them in a room, that there would be the requisite level of planning and training, as well that there's a requisite concern in designing a process for an offender to sit with a victim, that there's safety, that there's appropriate context. I know that there is an ad hoc judicial council committee of the courts who often gives information related to both to mediation training as well as to the skill set of mediators in our valley. There are a number of mediators who are already trained, myself included, to hold such a mediation if we were to pilot something or to gather a group of our colleagues. That ad hoc committee could also lend input and would be happy to serve at the request of this committee to ensure that you had information on behalf of the mediation community of Utah.
All right, thank you. That's helpful feedback. All right, who wants to go next? Mr. Carlson.
Thank you, Mr. Chair. Will Carlson from the Salt Lake County DA's office. At their best, mediation programs can offer victims empowerment and offer accountability to offenders and improve the quality of life in a community. At their worst, mediations can re-traumatize victims and perpetuate myths about who deserves sympathy and who does not. In February of 2020, on the wall of the bathroom in Berkeley High School, the girls' bathroom, they had written "boys to watch out for." Now, Berkeley High School has become infamous. It's been sued several times for failure to protect students from sexual assault. And so when the school saw this, they announced, we are going to have a mediation circle. And that caused outrage among the girls in that school. They felt like the last thing they needed was a feelings circle where the boys would again avoid accountability and responsibility. I can certainly understand why defense attorneys would want some sort of mediation when they were facing violent crimes, sex offense, mandatory minimums in the state of Utah. But those two situations where a defendant is represented by an attorney and a victim may or may not have an attorney are not situations where there's an equal power between the two. And that mediation, as the previous presenter indicated, is one that needs to be approached very cautiously. There are some situations where mediation would be great and could save resources, but we would recommend caution, and we would be happy to work with defense attorneys and any interested parties, and certainly would urge against any sort of mandatory mediation in the criminal justice system.
Thank you.
Thank you. Jeff Buman, I'm the Executive Director of the Statewide Association of Prosecutors and Public Attorneys. I echo what Mr. Carlson has mentioned, and I won't repeat it. I will say that there may be a space for this in the criminal justice system that we can agree to. I'm very opposed to anything that requires mandatory mediation where it includes victims. There is a balancing act between the constitutional rights of the victim, the defendant, and the statutory rights and duties of the prosecutor as he or she represents the interests of the state and the people of the state. And they don't always balance very well or very easily. And expecting mediation to balance that for us would be, I think, optimistic at best. But I will say, we think there is a space for this. We suggest that there may be the ability for defense and prosecution to work together on this and create something that would be beneficial to both victims and offenders. And we think a working group would be the way to go on this one, that we could submit something to a legislator who's interested in this. Thank you.
Thank you. All right, are there any other comments, questions, discussion? Seeing none. And close the public hearing, and now that Senator Kennedy's returned, we have a quorum again, so I'm going to bring it back to the committee for action, if any. So we can do no action, or we can open a bill file on the topic, or we can be creative. Representative Birkeland.
Thank you, Mr. Chair. Okay, with the committee, I would actually like to open a bill file and just address this in a working group and bring something back to the committee at a later date.
So open your own bill file?
Yes.
Okay. So the motion would be that the committee itself, that we take no action, with the understanding that Representative Birkeland is going to follow up on her own. Is there a discussion to that motion? Seeing none, all in favor say aye. Aye. Any opposed? Chair rules that passes unanimously. I need somebody to vote. It's the vote. I mean, making it too easy up here. Okay, our last agenda item is other items. Is there anything else that anyone would like to bring up to the committee today? Jonathan, can you give us a preview of what may be coming in June? I'm putting you on the spot, I know.
So one of the things that we're looking at for June potentially is competency to stand trial issues, as well as the intersection of homelessness and criminal justice. But that may be subject to change.
All right, thank you. Chair will take one final motion. Motion adjourned from Representative Gracious. All in favor say aye. Aye. We stand adjourned.